Hi, I'm Professor Mark Grabowski, and this video will discuss jurisdictional issues that arise on the Internet. Because the Internet is a cross-border communications medium with no single authority governing it, disputes between countries with differing laws often arise. For example, in 2013, citizens in France sued Twitter, demanding to know the identities of anonymous Twitter users who had posted anti-Semitic tweets on the social media website. Twitter balked at handing over the identifying information. After all, hate speech, as offensive as it is still protected by the First Amendment in the United States, and Twitter's servers, along with the offensive Twitter users, were both located in the United States. But in France, hate speech is illegal, and a French court ruled in favor of the French citizens. Eventually, Twitter reluctantly handed over the information. Consider the far-reaching impacts of this attempt to regulate internet and social media speech. Do the laws of one country apply to a company based in another country whose laws differ? Can a nation ever have global jurisdiction over speech on the internet? Such disputes are becoming more common for a few reasons. First, different countries have differing ideas on internet regulation. Second, our existing remedies for resolving international conflicts of law are inadequate for the internet. And third, with nearly 200 countries, there is no one-size-fits-all solution. Courts and commentators have long recognized these issues, yet there has been little progress made toward finding a solution to the internet jurisdiction dilemma. Given this situation, it is imperative to establish a workable framework for resolving such conflicts among governments with differing values and goals. This lecture will discuss some of the possibilities for doing that. Meantime, until we do that, this limbo over jurisdiction has severe consequences. For example, the economy suffers as businesses are less likely to invest and innovate due to legal uncertainties. .coms also waste valuable resources handling international legal disputes. And some users may find themselves facing legal claims for activities that are legal in the user's country, while others must surf the web without any certainty that redress is available for harms they might suffer online. This lecture will provide examples of recent and ongoing conflicts between countries involving the Internet. It will discuss the differing views of Internet regulation. It will talk about the inadequacy of existing remedies, and it will also discuss some possible solutions for working that out. First, let's look at some examples of international conflicts involving the Internet. You probably already know about Julian Assange, the founder of WikiLeaks. Both Britain and the United States are trying to prosecute him, but it's unclear whether he's broken any law, and whether either of those countries have jurisdiction in this matter. Here's another example. The United States often presents itself as the bastion of internet free speech, but it arguably oversteps its bounds sometimes. Consider the 2008 case of a British citizen who was living in Spain and operating a website with internet servers in the Bahamas, which sold holidays to Cuba to European citizens. But he had his domain name impounded by the United States government because the domain name was registered in the United States, and it appeared to break the United States embargo against Cuba. In another example, a German court could not seize the Facebook account of a German citizen accused of burglary as evidence because, although Facebook has an office in Hamburg, Germany, the data was located on a server in the United States. Even within the same country, there are sometimes disagreements about internet jurisdiction. For example, two Californian judges in the same court district disagreed about their jurisdictional competence to hear cases between a Korean plaintiff and an Australian defendant who used U.S. social media platforms. One judge initially ruled that the court did have jurisdiction to hear the case, but that was later overturned by another judge who decided, no, the court did not have jurisdiction. A big part of the reason these disputes occur in the first place is because different countries have differing models for internet regulation. Even within the United States, for example, there's a huge debate over the issue of network neutrality. Let's take a look at some of the different models for internet regulation that different countries use. One model is what's known as self-governance. This model insists that the internet community is capable of regulating itself, and promulgation of domestic and international laws is both unnecessary and undesirable. But that ship has sailed. Most countries already regulate the internet within the framework of their political, legal, moral, and cultural values. Another approach is neo-mercantilism. This model is based on the premise that the internet is essentially a vehicle of commerce. The role of government, therefore, is to ensure the free flow of commerce along the information superhighway and to remove any impediments. This model is considered to be the American approach to internet regulation. A third approach is culturalism. This model views cultural protection as the primary objective of internet regulation. Internet laws and policies are enacted to reflect and protect a nation's intellectual, aesthetic, and moral values, with little consideration of their global impact. The French ruling against Twitter illustrates the culturalist perspective. A fourth model for internet governance is what's known as globalism. This model requires multinational political, economic, technological, and cultural cooperation in regulating the internet. This model relies on treaties and international conventions to achieve that goal. Although international regulation of intellectual property and child pornography on the internet has made some progress, there are no international agreements resolving international jurisdiction. Now, that's not an exhaustive list of the different approaches to internet regulation, but those are some of the more popular ones. Now, international disputes between countries are nothing new, but why are they particularly challenging to resolve when it comes to the internet? There's no dispute that a sovereign state may create and enforce laws concerning activities within its own borders, but the internet is a cross-border space. In the traditional analog world, it is relatively easy for courts to determine the geographical locations of the persons, objects, and activities relevant to a particular case. Even international sea law, such as the United Nations Convention on the Law of the Sea, is based on territory. However, as online activities often involve actors and intermediaries in multiple physical locations, diverse sets of potentially incompatible laws and rules overlap and frequently are in conflict. Virtual frontiers do not map out neatly into boundaries of national territories. Content providers may physically reside in one place, conduct their business in another place, and locate their servers in a third location, and their content is readily accessible from anywhere in the world. As the French Twitter case and the Cuba travel case illustrate, cross-border platforms can host user-generated content that might be deemed illegal in certain jurisdictions, but not in others. Furthermore, attempts to identify the location of a particular user over the internet have proven extremely difficult, and many internet users compound this problem by intentionally hiding their location. Traditional principles of international jurisdiction, particularly territorially, are poorly suited for this sort of environment of geographic anonymity. As a result, courts have long struggled to come up with a satisfactory solution to these sorts of problems, and no progress has been made toward a uniform global standard for internet jurisdiction. So what can be done about this? Well, here are some of the common proposals for resolving these conflicts of laws. One proposal is a universal regulatory scheme. And the way this would work is an international convention would lead to a treaty establishing substantive universal standards for what's legal and what's illegal. The treaty would also create an international body that would promulgate civil and criminal internet regulations and jurisdictional rules. However, getting 192 nations to agree on standards and then to adopt them into their domestic legal codes seems daunting, if not impossible. Attempts to do this with outer space and the moon haven't worked well. Either few countries adopt the law, or it's so vague as to be toothless. Adoption of a universal internet law could also create conflicts between the universal internet regulations and the domestic laws regulating the same activities. Another possibility is all countries could agree to a global standard for determining internet jurisdiction. In order for that to work, a treaty would have to be signed by all nations that would create a single test for determining internet jurisdiction. It could, for example, be an effects test. Under this principle, a country could assert jurisdiction over conduct that has an effect but does not actually occur within its border. As with the universal standard, though, reaching a consensus would be daunting. A third option for avoiding conflicts of laws is to use filtering. Under this model, governments would regain control of their borders by placing blocking and tracking technologies at international access points or at the internet service provider's servers to act as centurions. So, for example, if France doesn't want its citizens to see anti-Semitic tweets, they could simply block those sorts of tweets or block Twitter altogether. In fact, many governments have already implemented such technologies to monitor and regulate internet activities of their citizens. However, such filters can easily be circumvented and won't solve issues such as defamation and copyright infringement. In addition, this could undermine the internet's infrastructure, and it is antithetical to its founding purpose of being a tool to share information. A fourth proposal for resolving conflicts of laws is a choice of laws provisions. Under this proposal, content providers and users could agree to resolve disputes in a particular forum via choice of law provisions in terms of service contracts. But there would need to be an international consensus regarding the validity of such agreements. This seems unlikely given that it would limit governments' power, and the European Union has been reluctant to allow forum selection clauses. A fifth proposal is, well, we could do nothing. Not all of the issues of internet regulation require solutions, but of course, conflict will persist if we do nothing. So what is the solution then? Because after hearing all these proposals, it kind of sounds like there is no sort of silver bullet, that they all have drawbacks. Well, the best model for internet governance is probably a hybrid that incorporates some elements from all five models. Internet governance is a complex task requiring a complex set of regulatory mechanisms. As a result, the optimal system of governance is a combination of regulation. Various stakeholders, including government officials, tech companies, and netizens, all need to be involved in that process. Organizations like the Internet Governance Forum and Internet and Jurisdiction have propped up to tackle these issues. Progress may also be achieved by using existing channels and devices, such as the United Nations. Admittedly, this solution may seem like a bit of a cop-out, but keep in mind, the reason for the deadlock concerning internet jurisdiction is because each of the most common solutions have significant drawbacks. There is no silver bullet, making internet jurisdiction, like so many issues involving internet law, something that will continue to plague and perplex us indefinitely. Again, this has been Professor Mark Grabowski. Thanks for watching, and if you have any questions, shoot me an email at mgrabowski@adelphi.edu.